Hello, and a very warm welcome to all of you from my side as well. I'm Eva Ritte. I work at the law firm GvW Graf von Westphalen in our Berlin office, and I'm happy to be able to present to you the legal side of this webinar today. I will be talking about EUDR compliance, about the status quo, what we observe in our clients, and on what we think you should have achieved by now or in the next 6 months. Here's my short agenda that Ingrid is showing you right now. I'll be introducing our team very briefly so that you know who you're talking to, and then I will focus on the EUDR implementation must-dos and can-dos. I've also inserted 2 slides on the recent changes to the FAQs, the guidelines, and the proposal to change Annex 1. I don't think we'll have time to go into this in detail, but so you have it on the slides, you can read on it further, or we can talk about it in the Q&A maybe. So the Green Trade team at GvW is a team of lawyers that specializes in anything related to supply chain due diligence. So anything that has to do with sustainability and due diligence in the supply chain is what we deal with legally. On the next slide, you can see a couple of the legal acts that we mainly work on. It's in German, but I think it's or partially, but I think it's understandable. Practically, we've mainly been working in the past year or 2 years on the German Supply Chain Act, the LKSG, and the EUDR, actually. Prospectively, of course, we'll also be working on the CSDDD once we all know how the omnibus process ends, and how it will be implemented nationally. And then we also have been working on the carbon border adjustment mechanism and the conflict minerals regulation. We're embedded in a larger team of foreign trade lawyers. So our team works a lot on sanctions, a lot of sanctions to do with Russia, of course, customs, tariffs, export control, foreign direct investment. So anything that has to do with international trade and limitations to international trade. And this, in turn, is embedded into a larger law firm of 250 lawyers across all of Germany and a couple of locations abroad. Here you can see a couple of our faces of the green trade and the international trade team. But without further ado, let me talk to you about what you're most interested in, which is the EUDR. So on compliance readiness and the current state of affairs, really what we see from our clients is a very mixed picture. So some larger companies are basically ready and compliant already, and several smaller or mid-sized companies are still struggling with very basic interpretative questions or questions of practical implementation. What is important for everyone is to remember the deadlines and timelines, of course, which for medium and large companies would be the 30th of December of this year, and for small and micro enterprises would be the 30th of June of next year. The must-dos that I've written down for you here are an implementation roadmap in 5 steps, basically. The first being that you need to understand your legal obligations as well as your own effectiveness. This is maybe the most important point because everything else builds upon this. And in case of doubt, we obviously believe that it's important to seek legal assistance earlier rather than later. This can be helpful with regard to specific legal interpretative questions, with regard to questions of specific effectiveness of different companies within your company group, with regard to matching the correct HS code with your products, and so on. For example, this last point can, for example, be much more complex than you would think at the beginning. We also see that in sanctions law a lot of the time, actually, that some products could fall within under one HS code, but also under another, or even 3 or more. So you have specialized customs lawyers that can be very helpful in giving you or judging it for you on if your product actually falls under the scope of the EUDR or not. And then, of course, there's also training sessions by the EU Commission. There's training videos online. There's lots of support and information out there by now. So this step you should, in the best case, have completed by now. So you should know your own effectiveness and have an overview of your legal obligations. Second step, probably even more work here is to collect your data. The legal basis for this step is Article 9 EUDR, where you'll find a very detailed list of information that needs to be collected, organized, and kept for 5 years. Partially, this data has to be directly included into your due diligence statement. You'll find in Annex 2 of the EUDR. Hence, this info really has to absolutely be there by the end of the year. So you should probably prioritize this information. With other information requirements, you don't have to directly insert them into your due diligence statement, but you have to guarantee that you've sort of collected the info and that you have evidence for it at hand. This is, for example, Article 9.1h, adequately conclusive and verifiable information that the relevant commodities have been produced in accordance with the relevant legislation of the country of production. So basically verifying that you've complied with the legality requirement of the EUDR. And this is, of course, a prerequisite that is much more difficult to comply with than collecting location data, for example, or at least it's a legal term requiring interpretation. So here we think that it's important that companies should, if they haven't already done so, make sure to do the interpretative work as soon as possible and really understand what this specific information requirement entails for them. Ideally, you should at least have started this process already, or even better, be at a near complete stage, or of course, have completed it. The third point is to conduct your risk assessment. Legal basis here is Article 10 EUDR. So on the basis of the information and data that you have collected under Article 9, you now need to conduct an assessment of risk for non-compliance of your relevant products. And there's, of course, various ways to practically do this. But in any case, you will have to address all the criteria that are listed in Article 10.2 for each relevant product. So, for example, where was my product produced? What are the product-specific risks? Is the supply chain particularly complex? Are there indications of a company in the supply chain being involved in illegal practices? A good hint here could, for example, be if any substantiated concerns have been submitted regarding a specific company under Article 31 EUDR. What other reliable information do I have? And so on and so forth. Ideally, you are in this process now or will start it very soon. Please note that this step can be somehow skipped or partially skipped if you're only sourcing from low-risk countries according to the EU benchmarking system. However, as Niels has already sort of raised already, we would be very, very cautious here as well, because the conclusion that you're really only sourcing from low-risk countries or areas needs to be based on a process of assessing the complexity of the relevant supply chain and the risk of circumventing the EUDR, even accidentally, and the risk of mixing your products with products of unknown origin or products from high risk or standard risk countries. And you need to be able to prove that you've gone through this entire assessment process and that there's really no risk or only a negligible risk of mixing or circumvention. So we would not recommend taking a simple not my problem approach, but to at least be have some general awareness here. Then, as a fourth step, if necessary, you need to implement your risk mitigation measures. This could be asking for additional information, data, or documents from your suppliers, carrying out independent surveys or audits, or taking any other measures pertaining to information requirements. And this is, of course, a very individual decision, so there's no specific time frame for this. Very much depends on what you find out in the steps beforehand and when certain problems pop up. And as the last step, of course, you need to submit your due diligence statements by the end of the year or the middle of next year, depending on your company size. What else do we have in terms of can-dos or recommendations? The first one would be to take or to attempt a comprehensive transformation instead of a box-ticking approach. So we recommend not just doing the bare minimum, but seeing the EUDR implementation as part of a bigger transformative process, potentially creating synergies between the implementation of the EUDR and the implementation of other supply chain due diligence obligations. For example, if your company will prospectively also be affected by the CSDDD. But even just within the frame of the EUDR, it is foreseen that you take a bit of a more systematic or structural approach. Because, for example, Article 12 of the EUDR also obliges companies to establish and maintain a due diligence system. And also at other points in the regulation, you find formulations like companies need adequate and proportionate policies, controls, and procedures. So it's within the spirit of the law, but it's also our experience that it makes compliance in the long run much easier if you integrate it into your company's policies. Second point would be to make your voice heard. For example, make use of public consultation processes like the one that was just closed by the EU Commission on the proposal for changes of Annex 1, but also use other channels. Talk to your national competent authority, to MEPs from your country, maybe engage in public dialogue. Because there are so many, or there have been so many questions of unclarity and uncertainty with the EUDR, that it's important to realize that you can maybe contribute to shaping the understanding of the EUDR, or even contribute to changing some specificities of the law in the future. The third point that we also find very important is stakeholder engagement. We've talked about that a little bit as well already. So engage with stakeholders on all levels, because this will make it much easier for you to understand specific issues and needs. For example, understanding the difficulty of providing written evidence for land use rights when both parties of a rental agreement in a certain country are actually illiterate, or when verbal contracts are the norm in a certain area. So it'll be much more helpful for you to know this, and then you can maybe develop a solution together on how to still find evidence that you need for land use rights according to the EUDR. But you can do this collaboratively with stakeholders. This is actually also an integral part of the EUDR that you can see in Article 30 on partnerships and cooperation. Yeah, but it'll also, we think, make your life much easier. And also be aware that you will not only be checked by public authorities, but that you may also be checked by stakeholders. Article 31 gives natural or legal persons the possibility to bring forward substantiated concerns on EUDR non-compliance, and then national competent authorities actually have to assess these concerns and have to go after them. So it's much easier, we believe, for companies to take a collaborative approach with stakeholders right from the beginning than to get a national authority involved, of course. And then as the last point, obviously, we also recommend consider using a digital tool. This should ideally have happened already, because we see also in our from our clients that it can help very much already to bring structure into the relevant information and data, and to not drown in this overload of information. So these were my must-dos and can-dos. As said, I won't go into detail about the substantive changes of the EU Commission's interpretation of the EUDR that we have just seen in the new FAQs and new guidance document, but we can maybe talk about that a little bit more now in the FAQ session in case you have any questions about specific points there. Or else on the last slide, you can also see my contact details again. So you can always reach out to us, to me or the whole team, and we're glad to assist with any EUDR struggle that you may have. Thank you very much for your attention.
Thank you, Eva. That was great. You set the bar very high. I'm sure everybody will have more on their to-do list, even those who said that they were already fully prepared. But now a particular question, because we know there's also some people in the room that are further downstream, and some of the changes you were highlighting also affect those further downstream. Can you say a bit more about how the situation changed for them with the recent updates?
Yes, I can. About the so market participants or traders and operators further down in the supply chain were for a long time pretty unsure about what their obligations would actually be in the case that a operator or trader further up in the supply chain has already submitted a due diligence statement, and if they would still have to go through the entire due diligence process themselves again. And there has been a clarification in the new FAQs on the term "certain." in Article 4, I think it's point 8 or 9 of the EUDR, because it was always very much, it says, okay, you have to ascertain that the operator or trader or the operator before you in the supply chain has fulfilled the due diligence, but no one really knew what ascertaining means. And so now in the new FAQ, we can read that this is actually a very small legal obligation only. So the only thing that you have to do according to the new FAQs is to record the reference number of the upstream due diligence declaration and check their validity, and then refer to this number in your own due diligence statements. So the Commission itself speaks of a minimal legal obligation for downstream operators. From our experience, many companies had assumed that they were actually subject to further obligations in order to comply with the term ascertain, because ascertaining sort of sounds as if you really have to make sure that something has been done. And only having a due diligence statement doesn't necessarily mean that the content of the due diligence statement is correct, that the process that happened before is correct, and so on. And so we would actually still be very, very cautious with only fulfilling this minimal obligation, because in the event of a breach of the EUDR, you remain ultimately responsible, which is also stated in Article 4, paragraph 10 of the regulation itself. So what else could you do? Of course, in any case, it's recommendable to probably have a contractual protection for passing on the reference number. So have certain clauses in contracts with your suppliers that oblige them to give you the relevant information. But then you could, of course, also check the plausibility of the information in the due diligence declaration. You could address a questionnaire to your supplier or to certain suppliers to check the EUDR compliance systems and procedures. You could collect information yourself. In the worst case, you could go somewhere and conduct an audit. So there's a multitude of measures that you can still take, and that the Commission, interestingly, also notes down in the new FAQs. So you can see that the Commission also, they say it's a minimal legal obligation, but only if you can be sure that your previous supply chain participant does everything correctly, and you can't really be sure of that. So I think also not knowing how cautious or strict national competent authorities will be, it is very advisable to have some papers in your drawer that prove that you've done a little bit more than just looking at the reference number of a due diligence statement, especially if there's any indication that something might be off in the supply chain.
Thank you, Eva. That is a very complete overview there.